They have till now in GS this old prison manual which is of 1894. 1894 prison manual is of no practical use anywhere. Even the jailers tell us that if we go to use the prison manual, you won't be able to live in jail, and if you go to use it, we won't be able to live in jail. The prison manual out there doesn't work. So ultimately, it's the jailer who decides. It's his money, as they call it, arbitrary thought that he, according to the prison manual, you're supposed to get one letter per day, per month to read and also to send. That is, say, 100 years ago. Now you can give much more. You can give much more, but the jailer will decide them. So the rules they are kept in the prison manual, but the rest, all the functionings are by the jailer's money. He will decide whether you require to write, you need to write more letters. He decides whether you need to get more food. He decides on all those things. So the question is, what I'm trying to say is that there is a prison manual, but it's so archaic that basically it is the jailer who decides everything. And if you dare to talk about the jailer's corruption, you dare to talk about corruption in the jail, your letters writing, he'll come and tell you the next day, take care, you are not supposed to write more than one letter a month. You will get such dhamkis as you call it. That's part of the system. Another thing I would like to talk about jail, which recently is coming a lot of time in the media, is that with regards to 2G accused, is that the jail is a great equalizer. I think so that's a big fallacy. The hierarchies that remain in society exist in the jail also. Whether it's caste, whether it's class, whether it's money. I've seen, in jail, if you have the money, you will get a good place to sleep. If you don't have the money, you have to sleep in the barrack next to a toilet. If you don't have the money, you have to sleep next to the water tank, and you'll be wet throughout the night on the cold season. So it's what they say is that jail is a great equalizer. I don't think what my experience is there is that in jailers have also money calls the shots to an extent. Another question which people have been asking is, what have we been doing as political prisoners in jail? Basically, when are in jail, a big time of ours has gone into helping people. There are lots of applications to be done, and the fact that I would know some sort of English, to write an application, to write a petition, this has taken much of our time, and then reading papers, reading books, that has also been part of our daily routine. I will go to the main topic, which I feel that media has failed in the past 3 or 4 years, has focused on the question of rearrests. Actually, for under-trial prisoners, Naxal related, there are 2 massive problems which actually stand before them. One is that since January 2011 till now, they have not been produced before the Gadcholi Sessions Court at all. This you will find nowhere in the state, but in Gadcholi it is happening. In Gadcholi, people are not taken to the Sessions Court. Why? Because the police is required in Naxal Virodhi Abhiyan. So you get a situation that from January till now, no court production takes place. So trials are going on, witnesses are examined, but the accused is kept in jail. He is not allowed to go to court. If this very situation would be in Bombay, it would be hangama by now. But it's in the corner of Gadcholi, no one takes care about it. This is called the free trial that many of the tribal Adivasis have to face out there. The second problem which I think so I'd like to focus on is the question about rearrest. The question of rearrest is not something which has started from my case. Actually, as far as I've been in jail from 2007, this has been a recurring event. There was someone in 2007 by the name of Mallesh. Actually, I was not able to get the photos of his rearrest, but this exact same style in which I was rearrested, he also was picked up. Yes, in September 2007, he came out of the gates, abducted, taken. For 6 months he was sent back to Nagpur jail. Again he was released. That was in April 2008. Got released, again picked up at the gate in a similar fashion, sent back to jail, this time to Bhandara jail. When he was released from Bhandara jail, again he was picked up and then sent to Balaghat jail. This is the rule of law. The point I'm trying to make is, it's not a question whether he is Naxal or terrorist or whatever. The question is that the courts, you have put these number of cases on him, and the courts, if they have ordered him to be acquitted, if they have ordered him to be released on bail, it is a rule of law that holds that he should be released. But the police are not following this procedure. That is the case of Malesh. Ever since that, when this issue of rearrest took place, we jail had a hunger strike. It lasted for about 27 days. I don't know if many of you all remember, but at that time the Honorable Home Minister had asked the police department to hold an inquiry into the issues that we have held before us and which we have brought forth. The police department did an inquiry. They did an inquiry about the cases put on us. And then what happened next was, his last suggestion of the police department is that all these people who have gone on hunger strike should be distributed in various jails. This is how they solve the problem. This happened in this happened in April 2008, and the question of rearrest has been going on. Now, what happened in 2011 with me, September, I think so many of you know about it. I will just bring 2 or 3 facts before you all. I don't know whether it has come before. Is that we have been commenting about rearrest for quite some time. At least from jail we have been commenting, and many of the lawyers have been trying to raise this fact about rearrest time and again. But something it's worth noting is that even the principal district judge of Gadchiroli, now let me remind you that the principal district judge is the chief judicial authority in the district of Gadchiroli. Means you could say he is the guy who supervises the entire court functioning of a district. He has commented upon the modus operandi of the police of rearresting persons. This is one of his quotations in his judgment with regards to another trial by the name of Ganpat Purvite. His petition at the moment of rearrest is pending before a high court. I just read the wordings to it. If you want a copy, any of you all can either it's on the net, I think so it's on the net, and or you could I could provide you one. This is what the judge says. It is noticed that it has become the modus operandi of the police to involve any person branding him as an Naxalite. If any person is resident of that locality, if there are certain incidents, the persons from the area are implicated. The accused Vishwanath, that is Ganpat, is the accused before me in a number of cases, and it is noticed that as and when he is acquitted in one case, he is implicated in another case with intent to languish him in jail. That is his tragedy. This is the judge saying. Be that as it may, when there is no evidence, even the slightest against the accused to prove the charges, the accused has to be acquitted. This is in one judgment. He has given similar quotations in about 2 or 3 judgments. I'll read another one, just a short one. It appears that the accused is branded as a hardcore Naxalite, and police, with intent to languish him in jail, as soon as he is released from one offence, booked him in another offence, and thus kept him in jail. The accused was in jail in connection with another offence of Bhamragar, and on warrant he was released after the bail, and then supplementary charge sheet was submitted. That is the statement of the PSI. He did it as per the instructions of the Superintendent of Police. Would mean that the higher police officers are bent upon to keep Vishwanath behind the bar and solely with the intention he is implicated in such a case. That amounts to a curtailment of fundamental right of the accused, that is the right of liberty for which the accused can prosecute the concerned court as well as prosecute the concerned officer as well as claim the damages against the state. This is said by the principal district judge of Gadchiroli. The judge has said this. The judge had served such judgments even to the police department, but the question of rearrest continues. In the petition which my lawyers have filed, we try to compile a chart of how many people actually get rearrested? Now these are the figures that no police department is going to give us. But most of the people who get rearrested at the gates, they get arrested and they come back in the same jail. So that's how we know. Or some of them through letters or something we know that they are in other jails. Now this is a list of some 28 people. I am one of them, so you could call them 27 excluding me. Is all these people have been released on bail or acquitted, except for me and another person. All have been released on bail. But as soon as they go out, they have been arrested and they have been brought back. Some of the names out here, you will see in the past 6 months, you will get the same name twice. Because they have come into jail, acquire bail, go out, get arrested again, come into jail, acquire bail, go out. This is the cycling which is reoccurring. The question I am trying to make is that there are various Supreme Court judgments saying that if the state has cases against someone, they should say so when the bail application is before the court. My bail application was before the court. They said these are the 2 cases on me. Similar is to be done in any case where the bail application is before the court. But the police department does not do a thing like this and waits for a person to be acquitted and then goes to rearrest him. The method or the modus operandi which this judge talks about, I will try to explain it to an extent, because through my story I will be able to give you a picture about how the system works. See, when I was arrested in 2007, there was not a single FIR registered on me. My name was not mentioned in any charge sheet. Through Maris, RTIs have found that my name is not mentioned in any charge sheet. So in 2007, I have been put in about 8 cases on me. But after that, in due course of time, suddenly my name starts coming, or name or some Arun or some Wolf name or some alias or whatever, starts coming in some charge sheets as an absconder. Like this 22 cases which I was put in, my name starts coming in a charge sheet filed in 2008 and 2009 as Arun as absconder. After that, I have not been told for the past 4 years that I am absconder or I am in jail. Even the court has not been told that I am an absconder while I am in jail. But at the time of my release, these very 2 cases which have been shown, or my name has been shown as absconder, I have been rearrested in them. And I am taken to the court and the court is told, the local court is told, see, this is a person who has been absconding since the past 3 years. I am telling the court, no, I have not been absconding since the past 3 years, I have been in jail. But no, the papers show that I have been absconding, I am absconding. So I am back into jail. This is the process, this is the modus operandi which the principal judge talks about and is going on. These 28 people, I can talk to about each case about that, but it wouldn't make sense, it will take lots of time. But this is the entire process which takes place, and this is the thing which we have tried, the lawyers have tried to put it up as a petition before the High Court to show how the actual atrocities are being done. So, lastly, I would try to say that the question about rearresting at the gate, the point I would like to make is, to an extent we have thought about it, is why the department, the state, has a practice like this. Because like 8 cases were put on me, they can very well come to the jail and take me in the production warrant in 4 cases. But you do not do a thing like this. They wait till the time of release and wait to get me arrested at the gate. The only logical reason that seems from it is that you want to show that a new Naxalite is arrested. You want to show someone is arrested who we can call a Naxalite. So in the 4 years, the same person, I have not been released, but the same person I have been shown on the records has been arrested twice. So the number of people arrested by the custody people, police, if it was 20, it has now shot up to 40. No new people. So the same old people who have been released from jail have come back and they have been shown as statistics are double, and probably I don't know what else is double in the process. Probably comes. Anyway, I would Yeah, we'll go into questions. Lastly, I would say, try to say that there are many more political prisoners like this. In short, the case of Sudhir Dhavle comes to mind. I would not go into the details of his charge sheet or of his case, but he is basically victimized because of his thoughts. He is supposed to have written a book long time ago, published it in Bombay, but the Gondia police have arrested it and shown that as reasons for his support of Naxalism. Doesn't make sense. Yeah, the book was released, I don't remember when, but I think so about 5 or 6 years ago. But suddenly in 2010, the Gondia police arrested him and said this book is evidence that he supports Naxalism, which is totally false. So there are many political prisoners like that, and it's good if the media or civil society takes up the cause, because sometimes things that happen in the corner sometimes are known. Like the last time my lawyer, I think he came from this very same stage, and he said it's good that Arun Ferreira was rearrested because in the case of me being rearrested, the plight of many other people, political prisoners who have suffered through the same process, at least by this process, it is highlighted. So this is shortly what I would like to say.